without evidence cannot avail the plaintiff. It is trite that pleadings without evidence goes to no issue. See Section 131 of the Evidence Act. Flowing from the above, and in the instant case, the plaintiff did not give evidence to prove the facts of his purported ownership of the land he claimed. The testimony of the lone witness did not help this court or the case of the plaintiff in any way, as none of the means of proving ownership of land as initiated in the case, in the locus classicus case of Edudu vs. Okumagba, was proved by the plaintiff's witness. For the totality of the evidence adduced before me by the plaintiff and his witnesses, and in the light of the foregoing reasons, dispassionate evaluation of the evidence and findings reached above, and after a careful consideration of the totality of the plaintiff's case as made out in evidence before the court and the averments in his claim, I'm the considered view that I hold that the plaintiff has not proved his title to the land in dispute, either by purchase or by traditional history. I also find that the plaintiff has not discharged the onus placed on him to prove his case on the balance of probability. His evidence, having found not to be credible by this court, should not entitle him to the relief sought. The fate of the plaintiff's case is nothing but dismissal. On issue 1, whether the defendant counter-claimant, on issue 2, whether the defendant counter-claimant has, on the preponderance of evidence, discharged the onus of proof placed on him by law, prove any valid title to the land, to be entitled to the judgment of this honorable court. The law is trite, and the counter-claim is a cross or independent action completely distinct from the one brought by the original plaintiff, even though a counter-claim is tied to the original plaintiff's claim. In the counter-claim, the defendant counter-claimant stands in the position of a plaintiff, while the original plaintiff assumes the position of a defendant. It is equal to and not subservient to the main suit, and as such, must comply fully with the law with regards to pleadings. See the case of Ikem versus Dar Packaging Company Limited, citation as provided. A counterclaim is a cross-claim by a defendant that asserts an independent cause of action. That is to say that a counterclaim is a separate and distinct action, and the counterclaimant must prove his claim against the person being counterclaimed against before he can obtain judgment on the counterclaim. See the case of Ogire versus Oluwafunte Fumilayo and others, citation provided. The defendant counterclaimant improved of his counterclaim, pleaded and led evidence to show how he validly acquired title to the disputed land by production of documents as evidenced by Exhibits A to J. As I've already held above, that one of the recognized methods of establishing title to land is by the production of valid documents of title claim. This does not, however, mean that once documents of title to land are tendered in court, this automatically proves that the land therein purportedly conveyed, granted, or transferred by such document becomes the property of the grantee. The production and reliance of a party on a document of title carries with it the need for the court to inquire with some or all the number of questions, including the following. 1, whether the document is genuine. 2, whether it has been duly executed, stamped, and registered, whether the grantor had the capacity or authority to make the grant, and 4, whether it had the effect claimed by the holder of instrument. See the case of Alhaji Goni Kyari as Alhaji Uroma Alkali, citation as provided. I have taken a look at the oral and documentary evidence of the defendant counter-claimant vis-a-vis the documentary evidence put forward by the 8th defendant, as well as the traditional history as put before this honorable court by the 11th defendant. The counter-claimant in paragraph 10 of the counter-claimant's further amended statement of defense filed on the 23rd of September 2019 pleaded traditional history and also pleaded the traditional history of the land. In his pleadings, he averred that the parcel of land measuring 9.8 hectares, which he purchased from the Busa family, was deforested by their forebear named Nyaholo. It devolved to Waziri Nyaholo by inheritance after the death of Nyaholo Waziri was also inherited by Tanzago, Gadaguda, and Shagbanye. The land finally devolved to Alayayi Busa and Yamusa Busa, who sold parts of the land to the counter-claimant after he had bought a parcel from Tanzago Busa, referred to as Tikoti Busa. Paragraph 11 of the said further amended statement of defense the counterclaimant further avowed that he purchased the parcel of land measuring 3.27 hectares from the Amadu Arua of the Arua family. The land was funded and deforested by Dangana. It devolved to Ali, it further devolved to Bakwa Arua, and later to Amadu Arua, and finally to the counterclaimant by purchase. The avowments on traditional history as relied on by the counterclaimant are fully supported by evidence on record by testimonies of Alaye Busa, Amadu Arua, and the counterclaimant attached to the further amended statement of defense filed on the 23rd of September 2019 gives full flesh to the traditional history and the devolution of the land in dispute. Also, the counterclaimant in paragraph 16 to 20 of his witness statement on oath attached to the further amended statement of defense filed on 23rd of September 2019, as well as in the witness statement on oath of DW1 and 2, also gave evidence of the unbroken, cogent, and coherent traditional history of how the various portions of land which make up the entire land in dispute devolved from their founders of the land about 200 years ago up to its acquisition of title in the land. On the other hand, the 11 defendant to counter-claim defense to counter-claim in proof of its traditional history, claim one late Zadimago Loba Zanya was one of those who do yearly communal work for his father on the land in dispute. An attempt to impeach the counter-claimant's evidence of traditional history. However, the daughter of the said late Zada Bamalo Zanya Ladi Sani testified as DWCs for the counter-claimant, where she denied that the 11th defendant to counter-claimant's father was ever farmed on the land in dispute, let alone her father working for him on the land. She informed the court that her father's farmland was close to the land in dispute. As such, she knew the land in dispute and its owners. She confirmed the counter-claimant's evidence of traditional history. Under cross-examination, the 11th defendant to counter-claim could not impeach the credible and cogent evidences by DWCs. To this end, I hold that the 11 defendants to counter-claims evidence could not be evidence enough to impeach the counter-claimant's evidence of traditional history. Flowing from the above and placing the traditional evidence of the counter-claimant side by side with the 11th defendant, it is the view of this court that the counter-claimant has satisfied the requirements of the law on proof of title to land in dispute by traditional evidence. I am fortified by this stance because DW1 and 2, who are direct descendants of the founders of the land in dispute, gave a narration of how the land was founded by their forebears and all the activities carried out by them and how the land evolved from the founder up to the counter-claimant. Worthy of note is that the evidence of traditional history by the counter-claimant transcends over 3 generations before the counter-claimant. There is no gap in the history and how the land evolved to the counter-claimant. No doubt, the evidence is cogent, positive, and conclusive. Similarly, the evidence was neither controverted nor successfully challenged by the plaintiff and the defendants to counterclaim. Hence, this court has no option than to act on it. Furthermore, evidence of long acts of possession and enjoyment of property is also a potent ground upon which declaration of title can be granted. As laid down in the case of Idudun Bosokumaga cited above, title to a disputed land can be established where a party is able to prove by evidence that he has been in long possession and enjoyment of the land. The counter-claimant in his further amended statement of defense on the 23rd of September 2019, particularly in paragraph 6, 7, B to F and 8, as well as paragraph 3 of the amended counterclaim of 7th February 2020, pleaded acts of long possession and enjoyment. The evidence of long acts of possession by the counterclaimant, aforesaid, includes his farming activities on the land since its purchase in 2000 and 2003, a period between 17 to 20 years now. Surveying the land, graded the land, which is further proved by tendering exhibits D, H, and G, planting of malina trees, and more importantly, selling about 4 hectares of the land to various individuals in Alhaji Ganiu Muyibi Bakere, Isegbekun versus Alhaji Sikiru Borigi Adelakun Citation provided. The Supreme Court heard